Welcome back. Up to this point, we've been talking about the common law approach to assent. In this subunit, we are going to discuss the UCC approach to assent. All right, let's discuss the UCC approach to assent. So the first thing you should know is that the UCC is mostly silent on assent. Now, if you have a sale of goods and you have an assent issue and the UCC is silent on it, what do? Well, remember, UCC section 1-103 says you flip out to the common law. This means that much of the discussion that we had about assent under the common law will also be relevant to the UCC, will also be relevant to a contract for the sale of goods. All right, in this unit, we're going to look at two provisions of the UCC, 2-204 and 2-206, and we're going to look at them in some detail. All right, let's see if UCC 2-204 is consistent with the common law doctrines of assent that we've already discussed. Let's look at 2-204 sub 1. Oh, there's the word conduct. A contract for the sale of goods may be made in any manner sufficient to show agreement, including conduct by both parties which recognizes the existence of a contract. What is that referring to? Conduct by both parties which recognizes the existence of a contract. Yes, that's referring to an implied contract, an implied in law contract, just like we discussed in earlier subunits. All right, let's look at subsection 2. Subsection 2 is pretty easy. An agreement sufficient to constitute a contract for the sale may be found even though the moment of its making is undetermined, right? So sometimes assent isn't as clear as two parties sitting down and having a contract signing ceremony. It's not as clear as offer and acceptance. Sometimes there is obviously assent by the parties, but we don't know the moment that they assented. All right, let's look at 2-206. Let's break it down into manageable chunks. Unless otherwise unambiguously indicated by the language or circumstances, an offer to make a contract shall be construed as inviting acceptance in any manner and any medium that is reasonable in the circumstances. Any manner, what does manner refer to? Promise or performance. All right, now let's look at 2-206 1b. This is a provision that is specific to the UCC, and it might be a little confusing if you don't understand the context. So let's go through it in a very deliberate manner. Unless otherwise unambiguously indicated by the language or circumstances, an order or other offer to buy goods for prompt or current shipment. All right, let's go through this piece by piece. We're looking for an order or other offer. Remember, usually the buyer is making the offer, and we call that offer an order. An offer for prompt or current shipment. What does this mean? Well, this means please ship the goods right away. Now, the UCC says that the seller can accept the order for prompt or current shipment by either promising to ship the goods or by shipping the goods. Once again, if a seller receives an order from a buyer for prompt or current shipment, the seller can accept the order by either a prompt promise to ship, I will ship out immediately, or by the prompt or current shipment, shipping out the goods. Right? So you can accept either by promise or performance. All right, but such shipment of non-conforming goods does not constitute an acceptance if the seller seasonably notifies the buyer that the shipment is offered only as an accommodation. What does that mean? Well, to understand this, let's look at this hypothetical. Buyer makes an order. Buyer says, please immediately ship 10,000 widgets model X1, right? Seller's reply, will ship immediately. Now 2-206 says, unless otherwise unambiguously indicated by the language or circumstances, an order or other offer to buy goods for prompt or current shipment. We have that, don't we? Buyer's order says, please immediately ship. This type of order invites acceptance either by a prompt promise to ship or by a prompt or current shipment. Here, seller has made a prompt promise to ship. So we have a contract here. Right? Now, of course, if buyer's order said something else, if buyer's order said, please immediately ship 10,000 widgets, model X1, please do not promise to ship them, just ship them. Then seller could only accept that order by prompt shipment. All right, let's look at another hypothetical. We have the same order from buyer. Please immediately ship 10,000 widgets, model X1. Seller then ships 10,000 model X2 widgets. Okay? Buyer ordered X1 widgets. Seller ships model X2 widgets. Now, what was seller thinking? Well, seller was probably thinking, buyer needs widgets immediately. I don't have model X1 widgets. Model X2 widgets are just as good in most circumstances. I am going to accommodate buyer and immediately ship out the model X2 widgets. Well, what's the problem with that? Well, the problem with that is that seller's shipment of the non-conforming goods is acceptance of buyer's order. So we have contract at this point. We also have breach of contract at this point. Look what seller shipped. Seller shipped non-conforming goods. Buyer ordered model X1, seller shipped model X2. So in one fell swoop, seller has accepted the order, seller has accepted the offer and entered into contract, and seller has breached the contract by shipping non-conforming goods. All right, let's move on to hypothetical C, which is almost the same. Buyer's order is the same as before. Please immediately ship 10,000 widgets, model X1. Seller ships 10,000 model X2 widgets. Looks like we're running into the same problem. But seller also immediately sends an email to buyer stating, we are sending X2 widgets and as an accommodation. We hope you can use them. Has seller protected herself in this situation from breaching the contract? The answer is yes. Under 2-206 sub B, 2-206(1) sub B, a shipment of non-conforming goods does not constitute an acceptance. So seller has not entered into contract with buyer. If the seller seasonably just means within a reasonable time, seasonably notifies the buyer that the shipment is offered only as an accommodation to the buyer. And here, seller has sent a seasonable notification that the shipment of X2 widgets is just an accommodation. All right, let's conclude our analysis of UCC 2-206 by looking at sub 2. Sub 2 is consistent with the common law doctrines of assent we've already discussed, where the beginning of a requested performance is a reasonable mode of acceptance. When the offeree accepts by beginning performance and not by promise. An offeror who is not notified of acceptance within a reasonable time may treat the offer as having lapsed before acceptance. Remember our common law doctrine? Our common law doctrine was that if you accept by performance or by beginning performance, you do not need to you do not need to notify the offeror unless you have reason to know that the offeror will not learn of the performance within a reasonable time. So here, this is not exactly the same under the UCC, but it is very close. An offeror who is not notified of acceptance when the acceptance is the beginning of performance within a reasonable time may treat the offers having lapsed before acceptance.